All right. Thanks so much for joining us for this estate workshop and planning. Let us pray. God of all creation, we give you thanks for this beautiful day in spring here. Lord, thanks for all those gathered here too, and thinking about what you've given us and how we can give that in ministry to building up your kingdom and sharing the gospel of Jesus Christ. Lord, as we put our minds, our hearts, and our words together, may we draw ever closer to each other and ever closer to you in faith, in discipleship, in living out this incredible gift of grace that you have given us in every way. In Jesus' name we pray. Amen.
For you. Okay, so our first presenter of today is going to be Alison Mathey Lambert. And she is a local trust and estates attorney who's licensed in Virginia, Maryland, and DC. Her practice is based in Tyson's Corner, and she serves clients both in person and virtually. She is a native Northern Virginia and has been practicing law for over a decade. She's a regular presenter at local community centers on these topics. She attended William & Mary for undergrad and Catholic University for law school. In her spare time, she enjoys swimming, running. She has 2 young children in the tote with the jogging stroller and competing in triathlons. She serves on the board of Arlington Masters swim team. All right, welcome, Alison, and thank you for joining us.
Nice to see everybody, and thank you for coming out today. I'm excited to talk to you, and if you have any questions, like she said, just feel free to type them in the chat function, and we can also address things at the end of everything as well. But I'm here to answer any of your estate planning questions. If you have kind of more personal questions, feel free to shoot me an email, and we can set up a consultation to talk about that on our own after this. But I'm going to go ahead and share a screen with you here. Hopefully you should be able to see this PowerPoint right here. Can we all see this? All right. Let me put it on full here. Let's see. All right. So I'm going to talk to you about estate planning today. Kind of the basics that go into it. What you should be considering. This is pretty applicable for anybody who's just kind of starting out, or people maybe who have done some planning in the past and want to revisit their decisions that they made, a decade ago. Laws change, and you always want to make sure that you are current with your estate planning, that your thoughts today mirror those that you set up, whenever you set up your estate planning. Estate planning is very fluid. It goes with you your whole life, and it's something that everybody should do. Regardless of asset size, you can have small assets, you can have large assets. I think estate planning is applicable to everybody. The reason is it gives your loved ones a sense of peace when a difficult time arises, whether that's an incapacity or whether that's a death. By outlining your wishes explicitly, you make things so much easier on your loved ones in a time of chaos. This is the best gift that you can give to your loved ones, to do it this way, to plan ahead. And basically, there are 4 parts to an estate plan that you should be considering, and we'll talk about all of those in depth. The first is a last will and testament. The second, if you choose to go this route, is a living trust. The third is a power of attorney, and the fourth is a medical directive. So we're going to start out, and we're going to talk first about a last will and testament. And this is a document that names beneficiaries, it nominates executors. If there's any minor children involved, it can nominate a guardian of a minor child. And it provides instructions regarding the probate estate. The reasons that we do wills is, number one, if you don't have a will when you die, the law has a hierarchy called the law of descent and distribution that would be applied. And this law says that if you die without a will with assets in your name alone at death, which means there's no beneficiary, no joint owner, or no trust attached to this asset, let's say you have a checking account, perhaps. Maybe there's $20,000 in this checking account, and you don't have a beneficiary listed on this checking account. You don't have a joint owner on this or a trust attached to it. This checking account is going to pass through the probate system. And your heirs at law would be the people who would stand to inherit if you didn't have a will, because the will can bypass these heirs at law. In Virginia right now, the statute says that your surviving spouse takes all of these probate assets if there's no children of a previous relationship. If there are children, those children will take 1/3 of those, or I'm sorry, those children will take 2/3 of the assets. A surviving spouse will take 1/3. If there's no parents or children, then no spouse or no children, it goes to parents. If no parents, then to siblings, so on and so forth. It's a very rare case where the state will take your assets. I think this is a myth that I want to talk about right now. People think the state will take your assets at death, and that's only true if there are no living heirs to be found. And I guarantee you there's always some heir to be found out there. I'm dealing with a case of a lady who was a nun, and she didn't have a will, and we're now going to great nieces and great nephews. And there are 14 of them. So we're trying to get signatures from all 14 people on this case that's going through the court system. And it's kind of a mess, trying to just get signatures, trying to do all this. This could have all been avoided if she had set up documents properly outlining how she wanted her assets to be distributed. One of these people we can't even find. They haven't been located in 20 years. They're probably in hiding somewhere, but yet they're still entitled to a share of great aunt's proceeds here because there was no will involved. So if you have a will, this will outline who takes your probate assets. And again, probate means the assets that are titled in your name alone at death. Another reason for a will is to nominate an executor. And this is a big one. Who do you want handling your assets when you're deceased? I don't know about you. There's some family members that I probably wouldn't want touching my assets and having control over that. I want somebody who has a good financial head on their shoulders who's handling my assets. I want somebody who's going to honor my decisions and pay any of my bills that are due, and finally execute my wishes. And that's the job of the executor. It's a tough job to be an executor for somebody. There's a lot of checks you have to go through. There's a big list of things. You have to pay a decedent's taxes. You have to make sure all their bills get paid. You have to, if there's a house, you have to liquidate the things within the house, sell a house, liquidate bank accounts. It's a big job. And being an executor, you want to make sure that the person is right for the job doing this. I get a lot of executors who come to me and they maybe need some guidance along the way, and I'm happy to guide them throughout the process. Otherwise, if you do something incorrectly, you could be held accountable to the court in that scenario. Another reason for the will is to appoint a guardian of a minor child. If you want to have any say, if you have a child under 18 who would take care of your children, at this point, you want to nominate a guardian through the will. Otherwise, you're left with a bunch of chaos and maybe a bunch of people fighting over kids. It's better to have something delineated and outlined for you in that horrific event that you died when your children were minors. Now, talking about the probate system a little bit, probate is done in the county where a decedent last resides. So here, if we're talking about Vienna, Virginia, that's going to be in the Fairfax County probate system. Fairfax County Court is located over in Fairfax City, over on Chainbridge Road. And probate is done primarily to protect banks. And this makes sense. Let's go back to that checking account. Say there's that $20,000 checking account. No beneficiary on it. No joint owner. Who is going to access this checking account? If you were to show up to a bank would not release this checking account to you just because you claim you're the spouse or the child. The bank wants the proper authority to release this account to. And they're not going to release this account until they have a certificate from the court. This is known as a certificate of qualification. Some other jurisdictions call it a letter testamentary. But basically, probate is done to get this certificate in order to marshal these assets. Once an executor is qualified by the court in the county where a decedent last resides, they can go and make a probate appointment and go ahead and get this certificate. But the bank isn't going to just release this account, like I said, to anybody claiming to be a beneficiary. They want the proper authority. Probate also protects the county. In Fairfax County, we are a very large county. Everything is done by the book and very specifically. Other more rural counties, you might have a little more wiggle room. Other states might have slightly different rules as well, but here I'm talking about Virginia. And the Commissioner of Accounts in Fairfax County is the person who marshals all this and kind of approve things that the executor is doing. When assets go through probate, it's kind of a timely and costly process. Typically, there's a probate tax due on assets going through probate. There's also an inventory fee and an accounting fee that is based on the value of the probate assets. Typically, probate takes around 1 to 2 years on average to resolve as well. So that's why you hear of people dying and then their estate's tied up and you're waiting on things. And this is why you hear things taking so long when somebody dies. It's because their assets are going through probate. It's because their executor has to submit filings to the county, has to submit inventories, accountings, get approval on all of this. And all of this could be avoided if you had properly titled your assets at your death. And by titling your assets, I mean having a joint owner on an account, or having a beneficiary listed, or having a living trust attached to this. And we'll talk more about the trust in a second. But the end goal of your estate planning is to make things as easy as possible on your loved ones. And by having to go through probate, that means it's going to tie up your estate time and money down the road, when you probably want them to have instant access to things, to be able to, pay your bills, to be able to care for minors, that type of thing. You don't want them tied up with the court system. When you're utilizing a last will and testament, that means that you are going through probate. And I tell my clients that a will alone is not enough to avoid probate usually. If you're utilizing the will, that means you had to go through the probate system. So it's fine to say, so-and-so gets my house, so-and-so gets my bank account, but unless it's titled that way at your death, it's going to still go through probate. And again, we try to avoid probate as much as possible. Probate is bad. That's the lesson to get out of this. We don't want to have to go through probate. Title your accounts properly. Make sure that they have either joint owners, beneficiaries, or trusts attached to them. And that's going to bring us into the next slide, the Revocable Living Trust. This is a document that establishes a fund to be managed by a trustee for the benefit of beneficiaries. And most of the time in a living trust, you are what we call the settlor and the trustee of your living trust. This is the best way to stay out of probate, to fund a living trust with your assets. And within your living trust, you can delineate your beneficiaries. Perhaps you give some to your church. Perhaps you give some to your family. Perhaps you give some to an organization. Whatever it is, you can establish all of this through a living trust and outline your plan giving that way. When you fund a trust, you take your assets, your checking account, your house, your brokerage account, whatever it is, and you link it to your living trust. For example, I have a house. I've titled my house into my living trust. If I were to die or become incapacitated, my husband, who is my trustee, can now manage assets for my benefit. My trust benefits me until I die. I still retain the same use and control of my assets. I'm just a trustee now of my assets rather than Alison, the individual. And nothing changes tax-wise for me either. Everything is still reported under my Social Security number until I die. I've linked all of my assets to my living trust. I say that I'm the one in control of it until I lose capacity. And then my husband takes over as trustee. If my husband's not around, then my mom takes over. And we have that all outlined very clearly. I have 2 young kids at home, and the trust also provides provisions for my kids if my husband is not around. All of this is set up so that theoretically at my death, we avoid the whole probate process now. I've made it so my trustee can access my funds instantaneously, to pay my bills, to use for the care of my kids, to give to an organization of my choosing. It's all outlined within this trust. I have linked all of my financial accounts to this trust, and I think I've just made things a lot easier on my family if I were to pass away. The last thing you want to do, like I said, is have to be dealing with probate when somebody dies. It's an unnecessary cost and expense, and it can be avoided if you do things properly. Things like IRAs and life insurance policies, any types of benefits-based accounts. I've made it so my trust is my backup beneficiary. My husband is the primary beneficiary. My trust is the backup beneficiary. And that allows for the scenario if my husband predeceases me or we die at the same time, my trust catches everything so it doesn't go through probate at that point. Things like an IRA, you can't title into a living trust while you're alive. Only on death is that allowed, and that's why we title it accordingly to say payable on death. The alternate beneficiary goes to Alison's trust. It's a great tool to provide for your loved ones and to make things as easy as possible on them. Another benefit of the trust is that it can avoid adult guardianships and conservatorships down the road. What this means is if you lack capacity down the road, either to manage your assets or something else, and 2 doctors have said that you're incompetent to do this, normally what would happen is you would have to go before a judge, and whoever was going to take control of your assets would then make an appearance before the court with you and get you declared incompetent. And nobody wants this. Nobody wants to go before a judge saying you lack the capacity. That's a loss of dignity at that point. So if you have set up and funded a trust while you're alive, young, and healthy, and you've done this, you don't ever have to go before a judge if you lose competence down the road. You can keep it a private matter and preserve your dignity that way by setting up this living trust. Trust also can avoid federal estate taxes. Right now, the federal estate tax exemption is very high. It's $11.7 million. Most people fall well below this, so I'm not really even going to touch on this, other than to say that there's certain techniques you can do if you are over this threshold of having to not have to pay federal estate taxes at your death. But come talk to me if you're in that situation. Trusts are also portable, which means that you can take a trust that you set up in Virginia and take it to another state, and it will be recognized in another state. Say you purchase another property in Florida, and you want to title this property in Florida into your Virginia trust, that's permissible. I have lots of clients who live across the country, and I work with them. We've set up a Virginia trust, and they're able to put other property into it. The trust is very fluid. It stays with you through your lifetime. You can change, amend, or revoke it up until your death or incapacity. And with estate planning, like I said in the beginning, it's wise to review your documents at least every decade because laws change, your thoughts change, and you want to make sure that everything is current with your current thoughts and laws on that. So say you set up a trust right now and maybe you want to change a beneficiary down the road. Instead of having to go to all your banks and rename beneficiaries, if you have the trust on your bank account, all you do is do a simple notarized amendment to your trust. And after that, your trust is amended. You don't need to go contact these banks every single time you want to change a beneficiary. You do that notarized amendment. During pandemic, I've also become an electronic notary. So we had back last March, a year ago, people were not leaving the houses, but they needed things notarized. Virginia allowed a provision to pass their legislature to permit electronic notaries to do certain things. Not wills, but certain things like trusts you can do all electronically now. Basically, I pull somebody up on the video like we are now. I share my screen with the PDF document on there. I give them mouse control, and then my electronic stamp goes on the document. It's a pretty cool process. If you don't want to go in person to get something notarized, you can do it all by video now. Most documents, not all, but most documents can be done electronically. Trusts are also private, and this is a big thing. When you go through probate, all of this is a public record. So anybody can look up what assets you had, who got what, when they got it. A trust will keep everything private. So the only people who need to know your assets and your wherewithal and all that is the beneficiaries of the trust. Trust replaces joint and payable on death accounts. We talked about, titling those accounts properly. If you have an account and you want to make your trust the owner on it, rather than adding another joint owner, you just title it into your trust. The drawback of having a joint owner on your bank account is that legally the other person is now an owner of this. They can liquidate the account and there would be no consequences. So if you were thinking of adding an adult child onto your bank account as a joint owner, adult child can liquidate that account and go to the casino if they want. The trust will keep everything benefiting you until your death. You can have an adult child as a trustee, but everything they do has to benefit you. It's not like they can withdraw the money for their benefit. And then on your death, you've delineated who you want that going to, whether it's an organization, the church, your family, whoever it is, different percentages, dollar amounts to certain people. You've done all of that within your trust. Trust replaced the need for payable on death accounts by having the trust as that backup beneficiary. You don't need to keep updating beneficiaries every time someone dies. The last thing you want to do on a death is have to go to the bank to keep updating beneficiary forms. If that trust is the catch-all on those benefits-based accounts, you don't need to worry about updating that because the trust is going to catch it. There's also no bonding fees with a living trust. When you go through probate, if an executor lives out of state, the executor has to be bonded over the value of the assets. The court thinks that an executor might run away with the money if they live out of state, even if they're over in DC or Maryland. They want to have that bond over the value of the assets. So that's another added estate expense that could be avoided if you properly title these accounts. Put them in a trust, make them payable on death, or make them joint. Could all be avoided. Trusts, you don't need bonding fees. I work with trustees. One is actually from London right now, serving on a Virginia trust. They don't need to be bonded, and we're working with him on his mom's estate at the moment. Trust can provide for minor children, stipulations for that. Maybe you want to leave your kids some money, but don't quite think if they got it at 18, they would be responsible with it. Maybe you want to stagger distributions. Maybe you want to say, hey, children can get all my money, but I want to put some limitations on that. Maybe they can get a third at 21, a third at 25, the remaining principal at age 30, something like that. You structure it and you tailor it to your interests and what you think would be best. So that's kind of a trust in a nutshell. If there's any questions about this, I'm going to address these at the end, but I think the living trust is the best way to keep your estate out of probate and to make things as simple as possible on your loved ones. Moving on to the power of attorney, we call this a general durable power of attorney. And this is a document which grants some rights for someone else for the ability to do financial and contractual decisions for you if you're unable to do it due to either incapacity or an absence. A very important document to have. The caveat is that power of attorney dies with you. You can't have a power of attorney over a deceased person. I have clients who come to me and their spouse has just died and they say, oh, I have power of attorney for him. And I say, well, you did while they were alive, but now that they're deceased, you no longer have power of attorney. You need to be an executor now. Executor is when you die, power of attorney is while you're alive. And generally speaking, your agent who is your power of attorney is also your executor. All of this deals with your finances. It's just in different capacities, either alive or deceased. When you have a power of attorney, you want to give this to the banks and financial institutions. In practice, I found some banks want their own in-house power of attorneys done. Theoretically, if you do one that's drawn up by the Virginia Code, this should suffice, though. Very important document to have, especially if you lose capacity, you want somebody to be managing your finances for your benefit. And then the final document that you want to consider is called an advanced medical directive. Other states call it a living will or healthcare directive. Our terminology in Virginia is advanced medical directive. Very important document. I think this is the most important one you can have. And it says that you're going to pick an agent to make healthcare and medical decisions for you if you're not able to make them for yourself. Anything from end-of-life care to organ donation to the disposition of your remains is all outlined within this document. It's so important to have this in place. It removes so much anxiety down the road in that tricky situation. If it's a chaotic situation, it's great to know what somebody's intent and wishes are and to have that on paper and to present it to a doctor. There's nothing like being in a hospital in this end-of-life situation, and family members can be snapping at each other, trying to figure out what the best wishes are for somebody. And if they had just produced a document, and done this while they were healthy, that said what their wishes were, it would make things a lot easier. Very important gift to your family. Do this directive and, prevent any chaos down the road from happening. And that kind of sums up the estate planning, kind of in a nutshell, of what the 4 documents are you want to consider and what you should be doing. I'm going to open it up for some questions now. Let's see. Any chats? Let's see. Allison, please speak about special needs trusts and arrangements for heirs. Great question. So a special needs trust is a trust that is set up for somebody who might be receiving government benefits. Maybe somebody has a disability of some sort. Maybe somebody is on Medicaid or on Social Security disability, some kind of government assistance program. And they're due to either receive an inheritance or they have received one. And we want to make sure that they're still receiving their government benefits. And we don't want this inheritance to count against their government benefits. It's a special type of trust that you can set up. And basically the assets are managed by someone else other than the beneficiary for the benefit of that person. And they're giving up control of the assets, still benefiting them, and they can still receive their government benefits in that scenario. So if somebody is getting Social Security disability or something of that nature, they get a large inheritance for mom who's passed away. Maybe the sister is managing this for the brother who has the disability. Brother can still continue to receive his SSDI in that scenario. All the assets from mother would still benefit brother, it's just managed by the sister now. And that's a great tool, great thing to have in that scenario. There's a lot of families I encounter of people with special needs. Any other questions? There's a bunch of different provisions you can do when you get into the nitty-gritty of trusts. Perhaps there's somebody you think who you want to provide for, but you think they might blow through the money. Maybe you put a discretionary clause or a spendthrift clause in there. So the money still benefits them, but there's some reins to pull them in on that if you think they're going to blow through it. Maybe somebody is going through a divorce and you don't want your assets being touched by the ex-spouse. Maybe somebody has a gambling problem. Maybe it's a bunch of different scenarios. There's constraints you can put on so that people can still receive the benefit of the money, but not get it outright, managed by someone else. Nancy asked, how often should an estate plan be revised? Every decade or so is a good mark. I find the laws typically change about big changes every decade or so. Even 5 years is a good marker point. I do a lot of complimentary consultations for people. If you want me to review old documents, I'm happy to check over old documents, see what's current, what needs to be updated. It's typically tax code provisions that change. Some most recent changes, digital assets are a big thing now. You want to make sure that those are incorporated in your documents. We have these digital footprints of photos, of iClouds, of everything. And old wills probably don't address this. So you want to make sure that you're current on that. Let's see. Bob asks, how do you address hierarchy of power of attorney or advanced medical directive to protect against the case where individuals named die at the same time or before you? Great question, Bob. You want to make sure that you have alternate agents. You want to have a primary agent, and then you want to have a backup agent. And there's no limit on the backups that you can have. I have somebody who went 10 deep in backup agents. That's probably a little extreme, but typically I see at least 1 or 2 backups. Typically, I also see people, maybe they don't want to offend a child. They want to have their children in there. I had a lady with 4 children. She wanted them all to be equal agents together with equal decision-making power. And I told her, I said, that could run its risk because then everybody has to agree on everything. And I asked, do they all get along now? Does anybody fight with each other? She goes, oh, yes, they do sometimes. So I think when you're choosing your agent, you want to make sure that this is the person that you want handling this stuff. And it's fine to have a co-agent on there. You can say each can act independently or each must act together. You just need to consider that when you're doing your documents. But put as many backups on there as possible. With your medical directive, it's always good to have somebody local on there. In case you need to go to the hospital or something and your primary agent or something is not available, have a local person on there, just in case. Does that address that, Bob? Where's Bob? Okay. All right. Pastor Tony says, how do you address the hierarchy? Oh, is that the same question? Let's see.
Just the same one.
Same question. Okay.
Dennis has one, though.
Dennis asked, talk about pour over wills. Great question, Dennis. When you have a pour over will, this revocable living trust that you've set up is now the beneficiary of your will. And this is the way to go. This is what I would recommend doing. This says that anything you forget to title into your trust or put into your trust is now going to flow through the trust at your death. This allows for all the tangible personal property and other things within your house to flow through the trust at your death. You can't title personal property. Say you've got your kitchen, your pots and pans, your jewelry, your TV, all the stuff within your house. There's no actual title to these. So it's just saying that anything that is sold off within your house is going to pass through the trust at your death. Pour over will is a great tool if there is a minor probate case. If somebody were to search your pour over will, they wouldn't be able to gather too much information from it. So it kind of keeps things private still, even if probate is needed. You can't generate too much information from a public search of a pour over will. So it's a great estate planning tool used in conjunction with everything. Let's see. Yvonne says Nancy's fan collection. Yes, Nancy's fan collection would be called a tangible personal asset. Unless something is specifically insured, then it is going to flow through this pour over will that way. When you're cleaning out somebody's house, I'm going to give you an example here. My husband was the trustee and executor for his grandparents. My husband also has a mother, an aunt, and an uncle. So you're probably wondering why the grandson was now in charge of his grandparents' estate when there are 3 children. Well, 2 of them are big gamblers up at the Dover Downs Casino, and the other one was going through a divorce. So my husband is the stable financial guy, has a good sound head on his shoulders, and grandparents kind of foresaw this, and they picked him to manage the estate. So we had the foresight to be able to link all of their assets to this trust that we set up. And his grandmother actually ended up living with us for the last couple of weeks of her life while she was on hospice care. And we were able to take care of her, honor her wishes. And she had a directive in place that said she didn't want any heroic measures. So that means, no tubing, no ventilation, none of that. And we were getting cries from family members to put her on this. And we said, nope, she didn't want this. And we were able to honor her wishes that way and produce that directive. We were able to sell her house not long after her death in something that I think was pretty warp speed. We did it in 2 months. We closed out the whole estate within 3 months. And other people are stuck going through probate, 2 years later. So by having everything in the trust and having it on file with the banks, he was able to just work, show them, the death certificate, go through everything. And, real life example, he closed out the estate really quickly. As opposed to if the house hadn't been titled into the trust, it would have gone through probate and we would still be there today. All right, let's see. Jerry says, with a revocable living trust, can your estate ever wind up in probate, assuming children have reached age of majority? Yes, and this goes back to funding the trust. When you set up a trust, there's no point in setting it up if you're not going to spend the time to fund the living trust. Funding the trust, again, means linking all of your assets to it, talking to each financial institution, giving them a copy or a certificate of your trust, and titling that asset to the trust, either in ownership or as a beneficiary on the trust. So say that you have this trust set up and you forget to fund a bank account to the trust. It's still going to pass through the trust, but depending on the value of it, if it's over $50,000, which is the small estate threshold in Virginia, it does have to go through probate. So it's always wise to go through all your assets and make sure they're titled properly. Make sure they're titled to that trust. Otherwise, you still have to open a probate case for that if you haven't titled it to your trust. That make sense? All right, Steve asks, how about the automobiles? Trust or let them pour over, or let the pour over will take care of them? Great question with the automobiles. So our lovely DMV, if you picture your non-COVID times at the DMV, DMV doesn't understand trust in my experience. In practice, yes, you can title cars to a trust, but in reality, I say don't do it. Put a joint owner on that vehicle. It shouldn't change your rates or anything. And as of October of 2020, there is a new law in place that lets you designate a beneficiary to your vehicle. As long as there's no lien on the vehicle, so no monthly payments on the vehicle, you can fill out a form with the DMV, designate a beneficiary of your vehicle, and then it's taken care of that way. So usually I recommend having your spouse on there as a joint owner. If you don't have a spouse, maybe an adult child. If you don't have a spouse or an adult child, maybe pick a neighbor or a friend or whoever you're leaving your estate to. You can even title the church on there if you want. I'm sure the church would love to get your vehicle at your death. All right. Let's see. Anna asks, neither does DMV in Florida. They don't understand, and it's very complicated. I think all DMVs are kind of that way. I know during COVID, you also have to make an appointment too. So if you're going to, the form you can mail in, you can fill out the form, print it out, mail it in. They should be able to address your beneficiary that way. Donald asks, how should timeshares be handled? Great question. Timeshares, in my opinion, you need to start liquidating them while you're alive, because after death, it's a lot harder to liquidate them. Timeshares can be titled in the trust. Title that, it's just a deed. Like what we do in Virginia, we do, it's what's called a deed of gift. It transfers from your name into your trust name. It's filed with Fairfax County or whatever county it is. Same thing with timeshares. It involves a deed transferring it from your name into your trust. There's no transfer tax due on that. So if you do have a timeshare that you don't want to get rid of, title it in your trust. Any assets that you have, you should link to your trust. That means anything from real estate, checking accounts, money market accounts, CDs, brokerage accounts, IRAs, annuities, life insurances, anything except for cryptocurrency. The law has not addressed things like Bitcoin yet and things like your cryptocurrency. So that's a new area of law. Theoretically, that should pass to your estate and trust as well, but the law has not kept up with the times on that. So I foresee something coming on that in the next probably few years. Yes, Nancy.
Your employer gives you a life insurance policy. Do you have to make sure that that's also in your trust?
Correct. So life insurance is a benefits-based account. So you want to, if you don't have a spouse, you want to make sure that the trust is on there either as a backup or as a primary. Bob asks, you mentioned filing a living trust with the bank. Does this apply to all accounts, or do you just share the trust with the bank after death? That's a no-no, Bob. So you want to make sure that the bank has your trust prior to your death. And that means funding your trust. Funding the trust is where people tend to balk. They've set up these documents and then they don't spend the time to fund the trust. And then suddenly on their death, you have a full-blown probate because you never funded the trust. So what I just say, go make a day of it, talk to all your banks, give them a copy of your trust, make sure that that bank account is titled in the trust name. Do it while you're alive and healthy rather than on your incapacity or death. It's a lot harder to do that. That make sense? Okay. Yvonne says, is a tax-deferred asset titled to the trust, will it lose its tax-deferred status? No, it won't. If it's payable, you mean if it's payable on death to a trust, or if it's like an annuity, perhaps?
Like
annuity,
an IRA, annuity.
like an IRA, right. An IRA or an annuity, you don't title it to the trust during your lifetime. You make the trust a beneficiary. In 2020, there was some new legislation called the Secure Act. And I'm sure, I don't know if y'all are familiar with this, but it used to be that if you inherited an IRA from mom or dad or somebody, you could keep deferring it and keep deferring it and keep deferring it. Now, Congress has said that you have to take all distributions within 10 years of inheriting it, unless you're the spouse of that person. But if, say, you're an adult child or something, and this is where planning comes into play. Say you want to leave your IRA to your adult child, who's probably in the prime of their earning power right now. And then suddenly they inherit this IRA that has been passed down from generation to generation, and they're forced to take withdrawals on this within 10 years. Suddenly your adult child is probably now in the highest tax bracket. And that's a big mess. So it's forcing people to make these, to take these distributions on it and bumping up their tax brackets now. It's another question for a financial planner and a tax advisor, but I'm happy to talk more on that if you guys want to hear more on that.
I think we are pretty good on our questions. Yes. All right.
And if you guys have further questions, please feel free to email me, and I'm happy to do a complimentary consultation for more personal things. Thank you for having me.
All right. And we're going to move on to our next guest, which is Yvonne Lembo, who Yvonne is known to us at the church. She's done a couple of sermons for us. And Yvonne is the regional gift planner with the ELCA Foundation for the DMV in the Mid-Atlantic. She has more than 40 years of ministry and professional experience, and she enjoys helping families and congregations establish planned gifts and endowment funds to reach their legacy and ministry goals. Yvonne is a graduate from Harvard University and the United Lutheran Seminary. She completed her coursework in the Certified Estate and Trust Specialist program of the Institute of Business and Finance. So thank you, Yvonne. I'll turn it over to you.
Well, hello, everyone. This has been such a great workshop. And Alison, thank you so much for the gift of your time and expertise, and for your excellent presentation and fielding all our questions. That's really wonderful. I'm also delighted to share the space with Mark Knauff from Thrivent, and Mark, so many of the families and congregations that I work with count on Thrivent products, Thrivent Choice Dollars, Thrivent Action Teams, both for their personal financial goals as well as their congregational goals. So I'm really glad to share this space with you. And to the plan giving and endowment team at ELC, you rock. It's been such a great journey over the past 3 years, and seeing you build such an awesome program for your congregation from the ground up. And I just want you to know, I brag about you everywhere. I share the website far and wide. And it's been just a delight to work with you and see the fruit of all your hard work. And also to my good friends at Good Shepherd in Alexandria, Pastor Lydia there. And I have really been enjoying working with Good Shepherd over the past month, focusing on planned giving. And we're going to have a workshop next week. So glad that this coincided and just flowing right in with our plans. And finally, to my gift planning colleague, Anna Lugo, who clicked in all the way from Florida. And many of you may recognize Anna for her starring role in our foundation gift planning video. And she exemplifies the best of the work we do. And I'm so honored that she took the time to be with us today. So I'm going to jump right in and share my screen. All right. Let's see. All right. Good. Can everybody see? Okay. So what I'm going to share with you today is how we can have a simple conversation to create your gift plan. Your gift plan is a one-page flowchart that illustrates how you want to distribute your lifetime assets to leave a legacy to bless your loved ones and the ministries that mean the most to you. Your gift plan can serve as a playbook in your meeting with the professionals on your estate planning team, like Alison or Mark or others who are on your estate planning team, so that together we can help you reach your legacy goals. All right, here is a sample of what a gift plan flowchart looks like. And the conversation that we have to create your gift plan is called a discovery. And the discovery conversation has 3 parts. We talk about family, faith journey, and finance. And each part of the conversation helps you to build out one section of your gift plan. So first, we focus on family. Who are the people you love? Spouse, children, grandchildren, siblings, nieces, nephews, parents. This part of the conversation builds the family portion of your gift plan. Next, we focus on your faith journey. So what have been the significant spiritual and service milestones in your lifetime? And what organizations are connected to those milestones? Could be your congregation, an ELCA ministry that has been important to you, World Hunger or Lutheran Disaster Response Global Mission. Maybe you volunteer with a local nonprofit ministry, or you give regular gifts to some other charitable organization. So this part of the conversation helps to build the ministry portion of your gift plan. Next, finance. We complete an asset inventory so that you can see, perhaps for the first time, the full extent of the lifetime assets you've worked so hard to build and steward over the years. This is often the most profound part of our conversation. And I recall working with a dear gentleman a few years ago. And when we completed his asset inventory, he sat in silence for a few moments and tears began welling up in his eyes. And when he finally spoke, his voice was husky with emotion. And he said to me, "Yvonne, I've been a simple working man all my life, doing the best I could to provide for my family. And in all this time, I never realized what I had. I just never knew." So through your asset inventory, you will be able to see that you have greater capacity than you imagined to leave a legacy that will bless your loved ones, your congregation, and the ministries that mean the most to you. So next comes the fun part. And this is what one couple I worked with described as playing with the monopoly money. And this is where you get to decide how you want to distribute your lifetime assets for your loved ones and the ministries that mean the most to you. So there's two main ways you can do this. You can slice the pie, or you can layer the cake. So when you slice the pie, you're going to be distributing your assets at once and assigning slices or portions for each person and organization that's a part of your plan. Now, here's 3 ways that you can slice your legacy pie. First, you can add ministry as an additional child in your plan. And here's a sample of a plan like that. So in this illustration, this family has 3 children, and they've added ministry as the 4th child in their plan. One of my colleagues calls this adopting a child named Charity. And so out of that ministry portion, they have created 4 generous gifts for the ministries that mean the most to them. And they're using a tool called a donor-directed distribution asset. And this is a tool that the foundation provides that can simplify your ministry distribution process and streamline how many different beneficiary designations you have to fill out. Alison mentioned in her presentation how you can use a trust in the same way. So it's one document, so you don't have to change all the other documents. You could just change the distribution agreement with the foundation, and we'll see to it that each ministry you've designated receives what you have determined to give to them. Now, the second way you can slice your ministry pie is to leave a tithe for ministry. And here's a sample of a plan like that. In this illustration, just over 90% of this family's assets have been designated for their family, and the remaining slice is a tithe for ministry. So I worked with a couple a few years ago, and while we were working on their plans, they received bittersweet news. The sweet They were about to become grandparents for the first time. And the bidder, their adult child and spouse, received the difficult news that the new baby they would soon welcome into their family had been diagnosed with Down syndrome. And so as the family took on the weight of this news, this couple decided to establish, Alison, a special needs trust from their estate to provide ongoing support for the lifetime needs of their special needs grandchild. And then the remaining portion of their estate, they selected 2 ministries that had been instrumental in shaping them, strengthening them, supporting them, and sustaining them to be able to make this special faith journey with their family. A third way you can slice your legacy pie is to give the whole pie to ministry. And here's a plan like that. So in this plan, you have a little pie crust over here that's designated for final expenses, and the remaining pie is given as a gift for ministry. So a wonderful woman I worked with had a life-changing experience midway through her health services career. She took a mission trip overseas and provided healthcare training for young people in a developing community. And those young people were so inspired by her mentoring that they went on to obtain advanced healthcare degrees, and together they formed the first hospital to serve their developing community. So those young people and that community became her family. And every year before COVID, she spent several months every year overseas in this community. And she also designated a generous annual gift to support the ongoing work of the hospital there. And with her whole pie plan, she set up an endowment to permanently invest. Basically, her one lifetime asset was the equity in her home and a few other things. And this funded this permanent endowment, which will continue her annual gifts for the hospital ministry forever. And that's the power of a good plan, that you can leverage whatever assets you have to leave a lasting legacy for the people and the ministries that mean the most to you. Now, the second way you can distribute your assets is to layer the cake. So with this strategy, rather than slicing your pie and distributing it all at one time, you can pass on all of your assets in layers over time. And for this, we use a gift instrument called a charitable remainder trust. So in the first layer of the cake, the trust is established and funded, as Alison spoke to us about with a living trust. Same thing with a charitable remainder trust. A trust with no assets is like a cake pan with no cake batter. It's just an empty shell. There's nothing in there. So you need to work with Alison or your legal advisor with your estate planning team to ensure that assets are poured into the trust, either through beneficiary designation or through your will or your living trust, so that the trust is funded. And once the trust is funded, like any good cake, it rises in value. And it's the rise in the value of the invested assets that make it possible to build the remaining layers of the cake. So in the next layer, the trust is going to distribute income from its earnings to your loved ones, generally 5%. These distributions can take place for life or for a term of up to 20 years. And that's why I mentioned the tax-deferred assets question, Alison. With a charitable remainder trust, you can extend the distribution period for tax-deferred assets from that 10-year cap due to the CARES Act out to 20 years or even a lifetime. You can also shelter highly appreciated assets from shrinkage due to capital gains tax because the gifts that you put into the trust are a charitable gift. So they're sheltered from that tax impact of capital gains tax. So after all of these income distributions are complete, in the final layer of the cake, the trust will distribute its remaining assets to the ministries that you've designated. And the nickname for this gift tool is the Give It Twice option, because of the rise in value of these invested assets over the lifetime of the trust. The final distribution to ministry is often equal to or perhaps even greater than the assets that you originally deposited into the trust when you established it. And here's a sample of a layer cake plan. So in this plan, the donor has taken one basic asset, their IRA account, to fund their charitable remainder trust. And it's funded by a beneficiary designation from the IRA account to establish and fund this trust. And in the next layer, the trust distributes its income first to her sister for life, and next to her 4 children for a term of 20 years. Then, in the final layer of the cake, the trust distributes its remaining assets for her ministry designations. And in this case, she has also set up an endowment fund that will receive the assets from the trust, invest those assets permanently, and provide a distribution to the ministry she's designated forever. So it's a sweet cake it's a way you can have your cake and give it too. All right. Now there's 2 ways that you can structure your gifts for ministry. You can give those gifts as an outright gift through your gift plan or an endowed gift. An outright gift is a lump sum that can be spent immediately and entirely by the ministries you've designated. So outright gifts can make a world of difference for ministry. Just this past year, Marlou Ridge, the camping ministry I serve in this region, they received 2 large outright bequests that literally tided them over through the financial impact of the COVID pandemic on their camping ministry. So lump sum bequests can make a huge difference. But on the other hand, your legacy gift is the gift of a lifetime. So not only will it be your largest gift for ministry in most cases, it'll also be your last gift. And so once it's spent, that's it. So a second way you can distribute that gift for ministry is to endow the gift. When you endow your legacy gift, instead of being spent outright, that gift will be invested permanently. And the growth in earnings from that permanent investment will create distributions for the ministries you've designated forever. So it's a way to give long-term impact from this gift of your lifetime assets. So the good news is that ELC has prepared to receive and manage both your outright or your endowed gifts for ministry. ELC has a gift policy that governs how they will manage your legacy gifts, whether outright or endowed, for maximum ministry impact. And ELC has also established a congregation endowment fund that's managed through the ELCA Foundation, where your lifetime gift can be permanently invested together with other gifts in the endowment fund and provide permanent distributions for the ongoing ministry of your congregation. GSLC also has set up an endowment fund with the foundation. So you can be confident that your gifts for your congregation will be managed for maximum impact. And I encourage you to get together with Dennis or Nancy, Susan, Greg, Pastor Tony, one of your communicators at ELC, or Chris or Denise if you're at GSLC, and find out more about your congregation gift policy and endowment fund and how it can help you reach your legacy goals for your congregation. So finally, your gift plan comes with gifts for you. It's a plan, it's a gift that gives back to you. So it's like these Russian nesting dolls, that there's gifts within the gift. So in addition to your one-page gift plan playbook, that illustration that gives you the big picture of what you've decided to do to distribute your assets, you'll also receive step-by-step instructions with everything you need to do to put your plan into effect, whether it's meeting with your legal advisor, updating your beneficiary designations, setting up your living trust with Alison or your legal advisor, or setting up other gift instruments that are part of your plan. You'll have everything you need to follow through and put the plan into effect. You'll also receive a gift acknowledgement form to document your gift and provide written instructions about how you would like your gift to be acknowledged. Also, we'll provide you with the ELCA Will and Trust Guide. And this is a handy resource where you can assemble all the details about your estate plan in one place. And this can help you during your lifetime. And as Alison said, make it easy on your family when the time comes that they'll have everything in one place and they'll know how to move forward. You'll also become a member of the ELCA Legacy Society. So the ELCA is so grateful for the time and care that you've taken to establish a gift plan, particularly when it's benefiting your congregation or other ELCA ministries. And as a member of the ELCA Legacy Society, you'll receive, I don't know if you can see it, but you'll receive a beautiful welcome packet that includes a thank you letter from our ELCA President, Kathy Summers, and a beautiful pin that you can have to commemorate and celebrate your generosity. But that's not all. Your gift planner is a gift to you. And this is thanks to the generous support of members of the Lutheran Development Alliance of Delaware, Maryland, DC, the ELCA Foundation, and your congregation, and over 1,100 other participants in the ELCA Foundation's Endowment Fund Pooled Trust. And this support makes it possible for gift planners like me to serve families and congregations like you absolutely free of charge or obligation. So what this means is we can meet and set up your gift plan with absolutely no money out of your pocket. And the only requirement is that your gift plan reflects the desire of your heart to leave a blessing for your family, your congregation, the ministries that mean the most to you. Finally, you receive the gift of confidence and joy that through your gift plan, you are leaving a legacy of your lifetime assets that will bless your family, your congregation, and the ministries that mean the most to you. So I don't know if are there questions in the chat. I have a few FAQs that often come my way, but if there's questions in the chat, I'm happy to address those.
Doesn't look like there's any questions in the chat, Yvonne, so you can go right to your.
I'll go right to the FAQs then. So some of these may have been on your mind. One, why wouldn't I just do a nice DIY, right? I can jump on LegalZoom and do my will. You just showed me all those boxes. I'll just fill them in. Bam, it's done. So, you know, the MasterCard commercial about priceless. So having expert assistance and advocacy for your estate plan is priceless. You've heard Alison's expertise and experience, and she was only just the tip of the iceberg of the different scenarios that come up for your family or your personal situation. So there is nothing like having professionals on your team who can help you get the results that you want to have in reaching your legacy goals. So I encourage, and in my case, you can meet with me for no charge. So it's not a big cost, but it's worth it to make the investment up front to see to it that you have a sound plan that's going to get the results you want at the end. If you have Thrivent assets, you definitely need to talk to Mark and make sure that you're taking advantage of the benefits of those assets. A second thing, we have a plan. Well, Alison mentioned, like how much dust may have gathered on the plan. So it might be time to look at it again and see if it's still lined up legally and if it still fits what you want to do. And so if you have a plan, hallelujah, let's fast forward to documenting your plan and acknowledging your gift and welcoming you as a member of the ELCA Legacy Society. What if things change? I don't want to be locked into something and then I'll need the assets. We have to go in a nursing home or there's an unexpected major expense. So things will change and so will your gift plan. And so once we set up the plan, we also set up times to review the plan at regular intervals in the coming years to update your assets, update your desires about what you would like to do. So I love, Alison, the words you used about a fluid document. It's a fluid document and it's written in pencil. It's not etched in stone. So you want to get it set up and then you go from there to keep it current. Another FAQ, we're not ready yet. Well, that's the easiest one of all. One word answer, COVID. So over this past year, of the millions of lives lost, I'm sure we could all tell stories about loved ones, co-workers, congregation members, community members that are no longer with us. And many of them gone too soon and did not expect to leave this world over this past year. But 100% of those who have gone on have left behind 100% of their assets, with a plan or without a plan. So even if you're a young person, you're like, we don't have assets, we have student loan debt and we're living with mom and dad. So you can get together with Mark and set up a term life insurance policy to create a safety net for those that will live on after you. And from that one asset, you can create a plan to bless your loved ones. You can even leave a share for your congregation or other ministries. So there's no reason not to set up a plan, no matter what stage of life you're in or what assets you have or don't have. You can create a quality plan that will leave a blessing for your loved ones and the ministries that mean the most to you. That's it. So let me stop share.
Thank you very much, Yvonne. We really appreciate it. Good to hear. Hi, thank you. One question I had is, so then I would set up a living trust with my attorney, and then under that, the charitable remainder trust would be part of that. So
you would pour assets from your will or trust into the charitable remainder trust, or you could pour from as a beneficiary designation from an asset. Alison, please take the mic.
Yes, you can. So you can actually set up a living trust with the remainder being the charitable remainder trust. So you can have charity be the beneficiary, basically, in layman's terms, and then go from there. But your living trust, you can set up and make that fluid throughout your lifetime. And then on your death, basically a new trust is created for the charity.
Okay, I see.
And then it's still going to do those layers. So it will provide income for your loved ones and then the remainder for ministry.
So it could take a long time before the church ever gets the money, right?
Well, the church will be here and ministry will be going on. You can always slice the pie though, and you can give now and enjoy now the effect of your generosity.
If I can add something to, since we're talking about testamentary trusts and all of that, is that it's really become a very good instrument now to consider for individuals who have enormously huge IRAs, for example, because with the Secure Act, that IRA would have to be distributed within 10 years, but with a charitable remainder trust, it can grow for another 20 years before it's ever distributed. And the income tax liability to the individuals is not going to be as huge as if you have to liquidate it in 10 years or less.
Right. Thank you, Anna. All right, Mark, are you ready? Okay. Here with Thrivent, Mark Knauff has helped hundreds of families achieve financial clarity by offering advice and matches both how the client lives and what they believe. He's backed by Thrivent's diverse products and an understanding of the giving heart. He brings nuts and bolts solutions to turn generous intent into tangible action, as well as holistic financial planning, assuring goals can be met. He's a praise band musician, a former youth director, and a preacher's kid. He is passionate about supporting pastors' families, helping all families with college planning and anything related to contemporary Christian music. Welcome, Mark.
Thank you so much. Can everybody hear me? Can anybody hear me? Okay, great. Good. Just want to make sure. Thank you so much. Yeah, so I really appreciate the people who came before me. Financial planning for legacy planning is, I believe, really a three-legged stool. You need to have three different professionals on your team. First one is, of course, your legal advisor who helps you set up the different things that you need to do legally. So we got Alison there. We also need the idea person, and Yvonne gave us some really great ideas, which I think were just phenomenal. So thank you for providing some of those. I'm hoping to add the financial element. The one person that is missing from this stool is the tax advisor, and we really encourage that if you do plan on doing any of these things, that you talk with a CPA who can kind of agree and guide you to any unknowns with tax advice. Stuff that we do we have to be tax aware, but we're not permitted to give tax advice. Conversely, the stuff that we do have to be legally aware, I'm not permitted to give legal advice. That's called practicing law without a license, and I'm not going to jail for that. So please see your legal advisor for anything that we talk about here today. So I'm hoping to talk a little bit about some specific ideas. The thing is that I've discovered is that most people who are probably on this call are want to participate, want to help leave a legacy and help the church and help their charities that they care about. So I'm here to talk a little bit about some of those things. So let's talk a little bit about this further. There's about 50 slides. I'm going to go through them really quickly and skip some. We talk about giving, why it's important. Everybody who's here obviously wants to be generous. And what do we call generosity? Well, we tend to call that, in its simplest form, a habit of giving without any expectation of anything in return. And we want to do that, but a lot of times we can't always feel comfortable that we can do that we don't have the capacity, that we have other goals that we need to accomplish. And we're a little concerned, so we may have some hesitancy. And I'll be talking a little bit about that later as well. So why do people do it? It makes them feel good while they're alive. It makes them feel good that they're going to be able to help people now, and it feels good that they're going to be able to help people in the future. So generosity is something that I think is innate to most people who are Christians. They're brought up to believe that they should share what they have, and there's different ways to go about doing that. First way is spontaneously. So when somebody knocks on your door and says, I want to sell you Girl Scout cookies, can you buy a pizza kit from me? The bell ringers when you walk in and out of Giant at Christmas time. It just creates a spur of the moment opportunity to give. Sometimes people just reach in and grab the change that they have in the cup holder of their card, somebody on the street corner. But we believe that generosity, while spontaneous, can also be planned. Kind of put a limit to it, have a bucket of cash or coins that you keep, and that's what you give away, or you kind of budget for it. What it does is, if you do have a plan with your spontaneous giving, and that sounds kind of contrary, spontaneous planning, it does give you the opportunity to say, no, you know, I've already contributed to the charities that I'm going to give for this month, this week, this year. Second way is intentional giving. Intentional giving is exactly what you do every week. If you have an automatic draw to go to church, or every month. Some people have the money withheld from their paycheck, and they're able to have a strategy. They know how much they're going to give every year. Feds have the ability to do that through their paycheck, through payroll. So it has a plan, and it tends to be more immediate. And that's the way that we look at intentional giving. The third way of giving is what we call strategically or planned giving. And I prefer actually strategically, because strategic planning, strategic giving allows you to integrate this to your other goals. Most people want to be generous, but they also want to get to the end of life and not run out of money. They want to get to the end of life, or get through life, and if they have a long-term care event, not have their spouse who doesn't have the long-term care event suffer because they have to dedicate every dollar towards that person's care. So coming up with a strategy to accumulate, to build, to put together your what level of wealth, whatever that ends up being, then dictates your comfort and your ability to create a plan to hopefully leave a legacy. And legacy is not necessarily just for your charities, but it's also for your family. Most people have built up, especially in this area, a significant amount of IRAs, and I heard a lot of discussion about IRAs, tax money that's never been taxed for the future. And people love talking about, they love talking about retirement, they love talking about their 401k, the value, and how to get there, but they really need to start off with something that's more foundational. And financial planning is really like building a pyramid. You start off with the most fundamental things. You know, the most valuable, I ask people all the time in my conversations, what's the most valuable thing you own? And people say, oh, my 401k, my house, I got a Mercedes in the parking lot. No, the most valuable thing they have is their lifetime ability to earn income. And if they're not around because they pass away, or if they're not able to earn income because they become disabled, that asset has become less valuable. So protecting that then allows people to then build the wealth, to accumulate the 401k, to go to work, to get those matches, that, you know, to invest in stocks, to buy their house and watch it grow in value and accumulate. And then there gets to be this definition here, defining line between accumulation and distribution. So most people have a protection plan. A lot of people get employer benefits, or they, you know, buy life insurance, disability income insurance, things like that. And they know about accumulation, building wealth, and putting to their 401k or the Roth IRA or the Roth 401k, their 403b, 457s, whatever. And they know how to build wealth, and they get a lot of advice of that. But a lot of people don't get a lot of advice and a plan on how to distribute that. Who here knows exactly the day that they're going to get called home? Who knows when they're going to die? I don't. Life can be long. Life can be short. We don't really know, but there's going to be a point where we're not going to want to work anymore. And we need to take what we've built over the years, and we need to figure out how to actually distribute that. If the distribution plan is put together properly, people will be able to live the lifestyle that they intend to live in their retirement. And if they're blessed and if they plan properly, there will be something left over at the end. And that's what the legacy is. But we have to be able to get here. And most people don't know how they're going to do that. So there's often a hesitancy to think about legacy planning because they haven't put together their distribution plan to project and understand whether or not they have enough money to get through life, and that there might be something left over for their family, for their charities, for their churches. And that's kind of where we're at. And we need to come up with that type of plan. So anyway, the legacy plan then does benefit, you know, again, the family, the churches, and the charities. And we have a bunch of strategies for helping people do that. And I'm hoping to talk a little bit about them. A lot of people think that financial planning and legacy planning is just for the rich. You have to be already rich. You have to be a trust fund baby. You have to have bought, Tesla at $4 a share, things like that in order to be able to do that. But that's not really true. Generosity is able to be achieved on just about any level if the planning is done correctly. It might reduce what I leave to my heirs, and it may or may not, quite frankly. If a plan is put in place, a lot of times what you intend to leave to your family will still take place. The kids will still get what they're supposed to get. The grandkids will still get what they're supposed to get. A lot of the strategies that we put together, the only beneficiary that does not get included tends to be your rich uncle, Uncle Sam. A lot of people don't really realize that if you have 2 or 3 kids, their shares may be dwarfed by the amount that actually ends up going to the government. And if most people live the normal lifestyle, the normal longevity that we expect, a lot of times they'll be passing away and leaving their assets to their kids just when their kids are in their peak earning years. They'll be at the top of their tax bracket probably for the rest of their life, and then getting a sudden influx of income will just mean that they'll be in a higher tax bracket. And a lot of what they intended to leave to their children and their grandchildren will end up being paid out in taxes. So there are some strategies using life insurance and things like that, where the assets can be paid out in the amount that the children expect to leave their children, but with some reshuffling of the beneficiaries for the tax deferred stuff. That can go to charity. They don't pay taxes, and the only one who gets shorted would be the federal government. And a lot of people like that. So we do have some strategies to do that. The other thing too, I think Yvonne alluded to it, as did Alison, that these plans can be changed, and that's the beauty of it. And then the plan giving only happens when you die, and we do talk a lot about that. But a lot of people want to see the joy and know that they can enjoy their generosity while they're alive, rather than just taking comfort that it'll all be done when they're passed away. So let's go ahead and proceed on, excuse me. Some planned giving features is that you may be able to give more than you think you can. And that's always really nice to hear. Or people get reassured when going through financial planning that they can in fact give what they want to give. There are times, very rarely, where people say, well, I want to give this amount. And I say, no, I don't think you should do that. Most of the time we find a way to work that out. They can give assets other than cash. One of the things, again, I had to miss a little bit. I have my dad's in town, so I was visiting with him for a couple minutes. There are other assets that can be given in lieu of cash, and they don't have to be at the end of life. Hopefully, somebody has mentioned QCDs, or qualified charitable distributions. Most people are starting to come to the realization that if they have IRAs, 401ks, once they hit the age of 72, they lose control as to the timing of liquidation of those assets. They have to have required minimum distributions. Required minimum distributions can be given directly to a charity, and it bypasses your 1040 form, so you don't have to pay income taxes on it, and the church benefits. So a lot of people have started doing that, using their RMDs and having those go to charities. So you can do that. The other thing too is a lot of people may have inherited stock or bought individual stocks, and they're greatly appreciated, and they don't want to cash them in because of the capital gains things. They can donate those stocks, the shares of those stocks, directly to the church, get the tax write-off for the market value of it. The church gets it, doesn't pay taxes, and they can cash it out and actually get every dollar, and there's no tax really on the transaction. See your tax advisor for further details. Again, I'm not permitted to give tax advice. However, that it does create an opportunity. So there are other assets that can be given. Setting up qualified charitable, working with a community foundation, an organization like the ELCA Foundation, things like that, can also create opportunities for family and future generations to get involved. I do have a really great case. I have a pretty well-off client They had a life insurance policy that is term policy. The beauty of our policies is that they're convertible. You can convert them to permanent insurance. So he had a $100,000 term policy that was about to expire. He converted it into a single premium whole life. They dumped I think it was $62,000 into it. They got a write-off for the $62,000. They donated it to a community foundation. What triggered all this is that his alma mater, University of Pennsylvania, wanted him to buy a charitable an annuity that would pay him income in his life, and then anything left over when he passed away would go to the University of Pennsylvania. Well, Pennsylvania had some, let's just say, some scandals a few years ago. They weren't really comfortable with that. They knew they'd be locked into that donation. They said, Mark, what else could we do with $100,000? And I said, well, let's use this life insurance policy. So when he passes away, if he lives as long as his dad does, the death benefit will actually go from $100,000 face value to about $217,000. They'll be able to fully fund this scholarship to the University of Pennsylvania for $100,000. He'll create a scholarship at his grad school down in the University of Texas, Austin, for another $100,000. His childhood Boy Scout camp will end up with $20,000 gift, and my congregation, Lord of Life Lutheran, will have $2,500 a year as a gift forever. So by taking the intention of someone who tends to be generous, looking at where they're at, looking how they can use that assets, it creates opportunities for the future. And then this charitable foundation too that will be created that's going to fund these two scholarships. If something happens again, the family can say, we don't want to give the money to UT, or we don't want to give it to the University of Pennsylvania, Penn State. We can change that. So the kids get involved in making the decisions. And again, it will just, if it's just set up properly, it will still ensure that what you intend to give to your family is able to be given to them, taking advantage of tax benefits. And if you want to have the income, you can have it. This particular family didn't need it, didn't want it. So they were able to create this trust. So planned giving strategies, there are a variety of them. As you can see, we already talked a little bit about other types. Beneficiary proceeds. Again, I know that it's been hit on quite a bit, but anything that is a qualified account, by adjusting the beneficiaries, it gives your beneficiary choices. Sometimes just structuring the beneficiaries so that they're allowed to disclaim and say, no, I don't want it, let it go to the next beneficiary, makes choices for the family available. Charitable gift annuities, I'm sure we've talked a little bit about that. Gifts of life insurance. There's a lot of people, especially Thrivent members. Thrivent's really well known for youth policies. I think after Gerber, probably Thrivent Financial has more youth policies than just about everybody. It's kind of interesting because I've got my policy from when I was a baby sitting on my windowsill over here. My parents paid $19 a year for it, and it covered me for $1,000 death benefit. By the time I cashed it in when I was 25, it gave me enough down payment for my house. But I keep the paper because I think it's important. So there are these policies that people who are my age now in their 60s, 70s, 80s still have. And they're like, my beneficiaries don't need the money. I don't need the money. Let's give it to the ELCA Foundation. Let's give it to the In Faith Community Foundation. We'll use it to start an endowment or some type of donor advised fund. So there's some options there. Or life insurance can be created from scratch to create that. The beauty of life insurance is it takes a little bit of money and it creates a large amount of money from very little. And it multiplies and leverages the generosity. So it's nice to use it. The only bad part is you got to die to be able to enjoy the benefit, but others will enjoy the benefits of your generosity, what you intend to do. Charitable trust. So the donor advised fund is when the money is left to a community foundation and the beneficiaries get to advise where that fund goes. So in the case of this family that I was describing before, if they had another scandal at a school, the family members who are making the advice can then advise the trustees as to change where the money actually goes. Of course, I'm sure Alison hit on wills and trust bequests and things like that. That makes it clear. We like to, in my industry, Thrivent at its heart is really an insurance company when you get down to it. We do everything else, investments and things like that. But I really like to make sure that the beneficiaries are designated properly. If they are, it just makes everything easier, and the wills and the trust can kind of catch the things that are not transferable by beneficiary, or when mistakes are made or something's neglected, or as Yvonne said, when the documents have dust on them and they haven't been looked at and the beneficiaries no longer are alive, say. We talked a little bit about qualified distributions from IRAs, always a great way to give now and to be able to enjoy it if you're age qualified and so on. So there were a couple different examples that were here. I'm going to kind of gloss over them because I don't think they're really applicable, and we got some really great examples from Yvonne and Alison. So why act now? Well, for one thing, it reduces uncertainty about what tomorrow brings. So if you have a plan in place, if you know that you have your income sources, you have your assets that are going to allow you to achieve your goals today. Say you're in your 40s, your kids are going to college, you're trying to figure out how to pay for that and pay for retirement too. But if you have a financial planner who kind of put together a strategy for you to build those assets, they're going to pay for those different things, income streams, they're going to help you pay you for the rest of your life, and that you're projected to still have something left over. Planning now helps with that. It ensures that your values are reflected in your plan. Again, a lot of people don't like the fact that a lot of their wealth, the things that they've built up, are going to go to tax dollars because they don't believe in that the tax dollars are being paid in ways that reflect their values. If you're able to put together a strategy, it will reflect who you are and what your beliefs are, and reflect that in that plan. And again, with proper strategies, it can not just take what you intend to give, but can multiply, leverage what you intend to give, and are able to give a much more significant gift. Some people, again, they need to worry about their retirement income. What if I need it now? There are ways to kind of play both ends against the middle. In other words, make sure you have income for yourself, make sure the assets available for yourself while you're alive, but designate it to go towards other things. But just in case, you still can have it there for you while you're alive, just in case the train really goes off the tracks. And then again, take time to consider ways to reduce taxes. Again, a lot of people just prefer to make the decisions themselves rather than let Uncle Sam decide where that money goes. So you can live a legacy now with proper planning. Again, we recommend that you have the three-legged stool of professionals. I don't know if you're familiar with the three-legged stool, but if one leg is missing, the stool falls over and you fall over with it. So your financial professional, someone like a Thrivent professional, or your whoever you're working with right now, an attorney like Alison, and then a tax professional. And I'm sure Yvonne knows some, Alison knows some, and I got a whole handful of CPAs that I refer people to who can help you. The other thing too is, at the end of life, sometimes if things aren't put down clearly, the family gets a little upset. People's feelings get hurt. I'm dealing with that right now. I had a client die day before yesterday, and they're remarkably well off, and the family's estranged, and the matriarch, the one who passed away, changed everything 6 years ago, probably not without communicating it to a majority of her family, and it's going to be kind of a mess. So having the family involved and on board with it just makes everybody feel better. The other thing too, by having the family involved, is it sets an example. Usually the senior family members can show their generosity and as an example, and hold it up, and then the kids, the grandkids and great grandkids can see that and hopefully follow along as well. One of the questions I ask my clients a lot when we have our first meetings is, what did you learn about money from your parents? That's usually the biggest influence of where people learn about handling finance. I can tell you that, again, my dad, he's a pastor, for a retired pastor, although they don't truly ever retire. I'm sure any pastor will tell you that. He preached on Sunday, and every Monday was his day off, and he'd pull out a shoebox of bills, and the first thing he'd do is stroke a check back to the church for 10% off the top. And that was a powerful example for me. when I was a kid. I said, wait, of course, I waited till I was 13 in my rebellious years, but I would say, I don't understand. Church pays you, then you turn around and pay back the church. Why don't they just reduce your salary by 10%? Wouldn't that be easier? And he's like, no, I want to go through the act of actually writing the check and giving the money back. And I was like, okay, took me a while to get it. Probably my 20s when my brain finally finished developing, but I did get it. And you learn quite a bit about how to handle money and generosity from family. And sometimes, again, if you have a generous heart and you want to pass that generous heart and grow the generous hearts of subsequent generations, sometimes setting the example makes a difference. And then, of course, including them on all the decisions. So anyway, we do have a foundation within Thrivent, the In Faith Community Foundation. Yvonne's familiar with it. She sent me an email earlier saying, I just love working with In Faith. They do such great stuff, and they really do. So this case that I had where the people bought the life insurance policy, they bought it and then they turned over ownership to the In Faith Community Foundation, and the In Faith Community Foundation owns it, and then they're also the beneficiary. And when they get the money, then they're going to set up this donor advised fund, and all those charities that they intended to take care of will get taken care of through that. It's a great organization. So what I would suggest for most people, again, is they want to be generous. They want to implement all these things that Alison's talked about. They want to implement all these things that Yvonne wants to talk about, but they're not sure that they can actually do it and still achieve their life goals. And that's where I come into play, or where Thrivent professionals come into play. So we look at investments, income tax, estate planning, risk management, retirement, where you're at, where you're headed, things that you've put together. We reinforce the fact that you're on the right path, or we say, you're not on the path that you intend to go. Perhaps we should make some adjustments. And really the only way to do that is to analyze where you're headed, project forward, and then kind of make some recommendations as to what you should do. Then when you want to be generous, you can be comfortable that I can make these commitments for things that are going to happen well past the end of my life, and know that I can get through life without having to worry about it. So we look at people, we discover what they have, we develop a strategy, and we give them the advice and help them put their plan in motion. So how long does the relationship last? I love questions like this, because the answer always in financial planning is, it depends. So it depends on where you're at, and everybody's situation is absolutely individual. So it's worth spending an hour and a half with a professional who can say to you, well, thank you, Mr. and Mrs. Lutheran. We really appreciate that you want to be generous and that you wish to endow $100,000 at the end of your life to the ELCA Foundation. Let's see what that looks like. And say, yeah, you can do it, or you can do it, but you're going to have to make some adjustments and come up with a strategy to get there. And sometimes it's like turning a speedboat or a jet ski. Other times it's like turning the Titanic. It takes a while. So the relationship can last quite a period of time. How much does it cost? Again, it depends. And the factors that influence the cost of coming up with a written financial plan involve the scope, what we're looking at, the complexity, and then the experience of the person providing the plan. So, my fees tend to be somewhere around $1,200 on up. I've never done one plan for more than $4,000, and that was very complex. Thing is that we want to just give you a blueprint, a checklist, and a roadmap on how to get to where you want to get to, and allow you to be as generous as what your heart is leading you to be, and providing a strategy to get there, and also cover your living expenses in retirement. If you're pre-retirement, your living expenses to get to retirement, to build up that wealth, and so on. That's the stuff that we really enjoy doing. So benefits of partnering with Thrivent. We don't see money as the goal. Never is. It's never about building up a pile of cash. It's about what can you do with the money, and how much do you need to achieve your goals. We put your interests first. 2 reasons it's the right thing to do. And it's also, we're fiduciaries, we're responsible, and we have to put your interests first. Compared to other financial services company, and this will be my only plug about bragging about why Thrivent is so much better than most other financial services companies. A majority of them, almost all exclusively, are for profit. There's either a rich guy that's getting richer, a stockholder that's making more money. Most companies that are profit seeking, their first interest is to put shareholder wealth above everything else. Thrivent is a not-for-profit financial services company. We serve the people who own us. The people who own us are the people who have financial products with us. So our priority is to take care of our members. And by doing so, it allows us to not pay income taxes. The beauty of that is that Thrivent is not a nonprofit, it's a not-for-profit. We are very profitable. All our profits go back to our members, our owners, the people that we serve, in the forms of lower costs, higher dividends, and earnings. But because we don't pay income taxes, we have to give away tax on what we do earn, and that's substantial. It's approaching $1/3 billion a year. So we have to give that away. Who makes the decision where those hundreds of millions of dollars go? Our owners, our members, the people that we serve, the people who have products with Thrivent, and we do that through various programs. So every week I get recruiting calls from other well-known financial services companies that say, come work for us. And I say, I don't think I could work for a for-profit company. I think there's an inherent conflict of interest. And they say, what do you mean? And I explain who Thrivent is, how we work. And I say, maybe you'd like to work for us. So I try to turn the recruiting calls around and get them to be Thrivent advisors. But anyway, it'd be one thing if we were a terrible organization. The other great thing about Thrivent is that we're not a terrible organization. We're actually one of the highest rated. There's 1,100 companies in the US that do what Thrivent does. AM Best rates them. There's only 7 or 9 that get the top rating, A++, and we're one of those organizations. So that's my little talk. I was able to compress 50 minutes of workshop into 20 minutes. I think I'm at time. If you have any interest in talking about your own personal financial situation, you want to take some of these wonderful ideas that you've heard today and put them into action and say, but can I really do that? We'd be glad to consult with you and give you a first pass look at what we think. Just contact us and we'll be glad to take care of it. Or you can contact your church leadership. They know how to get a hold of us. Thank you.
All right. Thank you, Mark.
Thank you, Mark. I don't see any questions in the chat, but before we close our workshop today, I'll just see if any of our participants, any of our audience members have any remaining questions or comments for our panel. And if not, oh, I do see Jerry has one.
Yeah.
Is that for Mark? I'll let Mark address that one.
Yeah, I think most people would agree. And again, the universal answer for all financial planning is it depends. If you have none right now, immediately and frequently at first, a lot of times it also depends on how far you are away from executing your plan. So if you're if I'm trying to go see somebody across town, there's a bunch of different routes and I can get there and they'll get me there eventually. But as I get closer to where I need to be more precise in my directions. And sometimes as I approach that, I need to be more frequent. So somebody who's in their 30s, every 2, 4, 5 years, again, depending on their situation. Somebody who's about to enter retirement, let's say 65, definitely want to start meeting with them on an annual basis, sometimes twice a year. I think the critical thing is, when do you really put the pedal to the floor and really come up with a strategy? Is going to be about 10 years before you plan to separate service. That's when most moves can be done. Most waiting periods for products are satisfied after 7 to 10 years. Most things that will cost you something up front are paid back within a 10-year span of time, and it makes more financial sense. There's also some tax moves and things like that. So critically, I like to meet with people if they're planning on retiring at 65, no later than age 55. And then as we get closer to that 65, much more frequently. And then I find that the most critical time is the year of retirement and then 2 years after retirement, because people are trying to get used to this new normal of what's the income like. Can I really live off of 70% of my previous income? You know, most of it's hand holding. Yeah, you can, because you're not putting stuff in 401ks anymore. You're using it. You're not putting money into Social Security payments. You're not putting money into Medicare. You can live on a smaller paycheck because it's technically about the same net. So those type of things. And then as people go through the 3 phases of retirement, the go-go years, where I've been waiting to do this my entire life, I'm going to go do it all in the next 2-3 years. And then the slow-go years where, yeah, I've been there, done that, healthy, not really costing me a lot, but I can do what I want to do. And then the no-go years where you have no choice because of health issues, kind of some hand-holding there. So I know that was a long answer for a short question, but it just depends.
Good. Yeah. No, thank you.
Mhm.
And I do want to say that Mark is, we're planning to set up a college planning seminar with Mark sometime as well, which probably is a different group of people, but we'll hopefully get that set up.
Right.
All right.
I think that's, if there's no remaining questions, that's our workshop. I would like to ask Pastor Lydia if she'd offer a closing prayer. And again, thank everyone, all of our speakers, our panel, all the other participants. I think it was a great workshop, good information. It's all available, recorded, and I believe there'll be a link where you'll be able to find that among the plan giving page of the ELC website. So again, thanks to everyone. Pastor Lydia.
Let us pray. Generous God, you provide for us all that we need and have instilled in us caring hearts to love our families, our friends, our communities, and our world. Guide us in putting to good use the knowledge and wisdom that we have learned so that we can follow your lead in generous living and abundance in our legacy. In your name we pray. Amen.
Amen. Thanks again, everybody. Have a good day.